we're live. Good morning. Thank you so much for joining us, everybody. My name's Marcelle Gordon, and you've just tuned into Scenario Planning in a POPI World, Unpacking and Preparing for the What Ifs. This is a very important conversation brought to you by the Mail and Guardian, along with our kind sponsors and experts for today. Trend Micro, they're a global leader in cybersecurity with a mission to make the world safe for exchanging digital information. And that does put them in the perfect position to help us understand what the Protection of Personal Information Act is all about. And if you've just heard about that, we've got news for you. You've got about a month to get yourself and your organization ready. It comes into effect on the 1st of July or 31st of June is what some people would say is your real deadline. And we're here to unpack everything. If you're like me, when it comes to these kind of technical computer-related things, you take the ostrich approach and you put your head in the sand until it's too late. So be with me, because this is an important conversation for me to hear if you have the same kind of approach. Enough from me now. We're going to be with you for an hour and a half to try and answer as many of your questions and thoughts and that kind of thing as possible. If you want to be a part of this conversation, we've got a chat room on the right-hand side of your screen that you've just tuned into. Please feel free to leave a comment, leave a question, and we'll try to get to as many of them as quickly as possible. Our panelists will engage with you as well if they have a chance, but otherwise I will cherry pick some of the more important comments made there and throw it to our esteemed panel. And let's get to that esteemed panel. With us today, we've got Emmanuel Tzingakis. He is the technical lead for Trend Micro, Sub-Saharan Africa. That's not a small area that he's in charge of. He joined Trend Micro back in 2018 and is with us here to lend his expertise. We also have Zaheer Ebrahim. He's the sales engineer at Trend Micro South Africa, and he's been technically involved with the IT industry since 2008. So real veteran is who we have at our disposal today. And then from a legal point of view, and I can see everybody leaning closer because that's what everybody really wants to know as well. Nadine is a senior associate at Bowmans, specialising in employment law and data protection, and that is why she is here. And they are our three experts here today. I'm merely here to moderate and try and get through as many of our questions and thoughts as possible. And let me just say, like they said at school, no question is a stupid question. This is why we're having this webinar today. So let's start with our panelists. Emmanuel, let me start with you. Why is it important for us to be having this conversation right now?
Thanks, Marcelle. Very good question. And if I can quote our VP for Trend Micro Sub-Saharan, Indy Sirawaza, data has become the new oil. And so much more so with personal information that has become a commodity on the dark web. Cyber criminals today are actually selling and have price lists for different personal information on the dark web. And as such, we need to understand what data we have in our organizations and how to protect it.
Right, that is a very good point of discussion. I think also just going forward from a housekeeping point of view, we've got some feedback coming through on our audio. So all our presenters, when you're not talking, let's try this, and you mute your microphone when you're not speaking, and let's try and remember then to unmute when it's your turn to speak. But I'll keep an eye and ear out for you as well. So that's our little opening statement there from Emmanuel. Zaheer, over to you. Let me bring you in here. I know men and women in your kind of position like to have your work speak for itself, but today we need you to actually speak because we desperately need your expertise. From an IT point of view, how massive is the changes that the POPI Act is going to bring from an information technology point of view?
Cool. Thank you. Thank you for having me on this panel, firstly, and all the praise that's out there. So the first point, when we're looking at an IT infrastructure perspective, I think it's very key that we look at a three-headed dragon, I like to call it. And the three-headed dragon that we always refer to is the people, process, and technology, and how POPI will actually affect that three-headed dragon. Because when we're looking at POPI, people first go back and assume, I can just buy one tool. I buy one tool, I become POPI compliant, and everything is happy. And that's not exactly how it works. If we look at a three-headed dragon and we look at the people component firstly, we need to be able to have our esteemed people like from Bowmans Law to be able to guide us in understanding the law perspective, so we know what security tools to apply to infrastructure. Then we got the process, because I can provide the technology from Trend Micro, but the process then comes in from you as an organization, your company. You need to tell me what is important to your organization, and that is where the identification of critical data is quite important. So even though IT infrastructure is quite large, we need to be able to narrow it down to this three-headed dragon, I like to call it, just so that we can understand how POPI can affect that as well.
Okay, Zaheer, we're going to be pressing on you quite a bit when it comes for that perspective. And also just a reminder for everybody, Zaheer is with us until 11:30. So if there are pertinent questions that you need his expertise on, make sure you get your questions into the chat room as quickly as possible. We've got quite a few people watching us right now. 146 have joined us. Thank you so much. Thank you for joining us. We'll be tapping into that chat room a little later. Quite a few people saying good morning and saying that they are happy to be with us. There were some comments on the feedback we were getting in terms of audio, but it does sound like we've fixed that now because everything is all smooth and listenable as well. Nadine, over to you now. You very much, I mean, you were saying some of the questions around this is so complex, and that is why, unfortunately, you are here, because out of all of us, you're the best person placed to answer that. Start off by telling us why there's a need for this POPI Act.
Thank you so much, and thanks again for having me, and welcome to all our participants. That is, of course, the crucial question: why is there a need to have this act in force and for us to comply within the next 30 days? So there has been an increasing sort of focus on what businesses can do with data containing personal information. And this is not surprising given your increase in data breaches globally. Closer to home, you know, we've seen Liberty suffer data breach, Facebook, and I think most recently Experian, and with a number of other jurisdictions having data privacy legislation in place for purposes of facilitating trade between countries, facilitating transfers of information. South Africa was behind the curve, so it was important for us to get our legislation in place, you know, for two reasons. One is obviously to prevent security breaches with personal information, to facilitate trade, but importantly for individuals out there, it's to really protect your right to privacy. You know, you have this right to privacy in the Constitution, and that right includes the fact that someone cannot unlawfully collect, process, and transfer their information. So this is going to be the end of an era where South African organizations really just collected information for whatever reasons they saw fit, and now they're going to have to do so a lot more diligently and in accordance with a number of conditions.
And I think for me, and like I said, these are the kinds of conversations I normally avoid because it's so complex. But when I started reading in preparation for this webinar, I think for me, repeatedly, the word that stood out for me is protection. And that's really something that all of us need, doesn't it? It comes from a place of trying to protect us from any kind of abuse or breach of security, Nadine.
Yes, I mean, that is the Protection of Personal Information Act. So it really is focused on protecting personal information. And interestingly, just on that point, you know, we as obviously individuals, citizens in South Africa, we have personal information, and we expect all organizations and entities that we do business with or have services with to protect our information that it stores. But further than that, South Africa, and specifically our Act, POPI, does actually recognize juristic persons having personal information, which is different to various other jurisdictions. Even your golden standard of your general data protection regulation in Europe only recognizes natural persons with personal information. So here, not only are you looking at yourself as an individual, but your company has information, and that will be regarded as your company's personal information, to which you can expect other individuals and entities to also look after it with care.
Why has it taken this long? It's now 5 years that they've been working on this. Why would something like this take that long?
That is always a good question and always a tricky one to answer. I don't think anyone is pronounced on that answer. I mean, I think the reason is we never had a general data protection legislation in place. You know, this is not an amended version. It's not building on another piece of legislation. So it really was something new for South Africa. Barring slight pieces of legislation, your National Credit Act or Electronic Communications Act, having some provisions, very minor ones, dealing with data protection. So there was a lot of structures that needed to be placed on the ground before you could try and enforce the act. That includes establishing your information regulator. They were appointed as far back as 4 years ago. And they sort of got onto the ground, got things running off, established committees, had to prepare regulations to provide us with guidance as to how to comply with the act. So I think that took a number of time to sort of get up and going. And of course, when we were hit with a global pandemic, it did sort of delay the signing coming into the act. But thankfully, we are now here. And as you mentioned, there is 1 month left to ensure compliance.
Indeed. And South Africans do like their last minute shenanigans, don't they? Emmanuel, let me bring you in here. I was very interested to read that you started your working life as an officer in the South African police force, which I thought was perfectly, placing you perfectly to talk to us about how to protect our information. Sorry, that's my one corny joke of the day. Emmanuel, where would an organization start to ensure that they are indeed POPI compliant?
So it's a good question, Marcelle. Thank you. So when we hear the word cybersecurity, a lot of companies focus on technology, and rightly so. Technology does play an important role in becoming POPI compliant. But many companies, or most companies, all of us need to have a holistic approach to cybersecurity and information security. It's not just technology that we have to concern ourselves with, but we also need to look at other areas, like Zaheer mentioned earlier, is the processes and the people, having a holistic framework to begin with, and implementing that framework to be able to protect yourself holistically, not just focus on the technology. We need a holistic view on cybersecurity.
Now, Zaheer, let me bring you in there. If you've got somebody like Emmanuel who comes to you and says, we need a holistic approach to our IT infrastructure, what goes through your head, and where does that leave you to start off your very important work?
So to be honest, if someone tells me like that, I'll just think about dollar signs, because I can sell you everything I can find. But from an advisor perspective, I'll actually go back to the advising level from a security architect role and understand what is the requirements. Because again, what data is important to a doctor and what data is important to a cashier is two different things. So we need to first identify the data. And just before I answer your direct question, I just want to add two things to both Nadine and what many statements were. Nadine mentioned the whole COVID thing and how that actually fast forward or fast track digitalization within our environment. And then many also mentioned the change of infrastructure and how infrastructure was changed between that. And we know that a lot of users started working from home, and that is very key when we're looking at personal information. I actually had a customer ask me this question, and at the time I didn't have an answer. And he said, what if I'm working for company A and my competitor is company B, and one of my employees goes home, they're working from their laptop, and that person's wife is actually an employee of company B? That now then forms part of a personal information infringement, because that is now invading on the privacy of that other user's environment. So there's a lot of use cases that we have out of there. If we go back to actually selling a lot of technology to fix this problem, which I like at the end of the day, but again, we need to identify what is his problem at the end of the day, identify what is the risk associated to it. And I think that is also very key, that even though POPI took a good, I think it's even more than 5 years to actually come into play, we need to now make organizations understand the importance of POPI and how POPI can actually be a driver for their business. If we look at how GDPR came into play, people didn't really take GDPR too seriously until the fine started coming out. As soon as people had to pay a very big fine related to GDPR, that is where it came into play. So even though it's not a scare tactic, we need to be able to motivate our organizations, actually entrust data protection officers in those organizations, because DPOs are very important for an environment. You'll notice, and I think we'll allude to that fact later, where DPOs are actually now part of most organizations and not part of the CISO's role. And DPOs are very important. So the first point of contact I'll actually be with is with the DPO and be able to have those discussions with them.
Does this process have to be expensive, Zaheer?
No. So when I look at technology first, and you look at something called DLP, which is data loss prevention, DLP and POPI is where they're going to work hand in hand. And even though it's not an expensive exercise, the time that is involved with it is an expensive material. So even though, like you mentioned, us South Africans like to leave it late, and I think we're leaving it a bit very late, but we need to be able to kickstart that process and be able to do it. So even though from a monetary value it's not expensive, we need to understand from a time perspective it is quite expensive.
And also the damage that it will help you prevent. So it's almost an investment in that regard. Emmanuel, there was a very good example that Zaheer used there about, which for me leads us to speak about how in our approach to the POPI Act, it's not just about securing ourselves to breaches from the outside. It's very much a protection of your information from inside, from your staff and that kind of thing, who inadvertently could be opening your organization up to breaches.
Absolutely. I think, Zaheer mentioned about data leak prevention and the likes. And I think one of the biggest areas that we need to focus on in protecting our data within organizations is creating awareness within our employees, understanding what data we are protecting, what data is important. Zaheer spoke about having a data custodian or data owner, protection owner, who oversees the information, is identifying those people, understanding who's got access to what data, and then creating policies or creating awareness around how you protect that data. What, we spoke about people working from home, and unfortunately, when people work from home, they tend to blur work and personal life, where they might use their workstations to do banking and the likes. And we need to create awareness with our employees as to what is important, how do you protect the data, if you're going to share that data, how to share it effectively and securely without exposing it to threat actors and or people that are not supposed to have that data. We've also seen the data digital transformation acceleration, with many people, many organizations now having to, with their employees working from home, having to find ways to make that application or whatever the resources needed by the employees more easily available. And so we've seen cloud adoption becoming a very important factor with many organizations, because it's easier to make data available using the cloud and cloud providers. So that's created a whole new footprint for threat actors exploiting those sort of vulnerabilities.
Okay, I'm going to bring Nadine in here, but before I do, I just want to point out, apparently some of our participants are still having some issues viewing us. You can also, if you go into the chat room, they've posted a YouTube link where you can also join us. So try that. That should be a more stable link as well if you are having problems right now. Nadine, I want to bring you in here because I think what Zaheer and Emmanuel brought up for me has set us up for a quick conversation around where the POPI Act brings us in terms of protection of the individual and the protection of the organization that they belong to, that they work for. And of course, the interesting diversion now being so many of your staff now not being under one roof and under one infrastructure. From a legal point of view, does that make the POPI Act even more complex than it would have been when they first started putting it together all those years ago? The protection of the individual versus, or including the protection of the organization's rights in terms of protection of information?
That's a very good question. And I mean, just to expand on what Emmanuel said, when we talk about threats to data security, a lot of organizations go straight to an Experian or a Facebook. And it means that someone's going to hack into our systems and steal all our information. And that's just not what POPI contemplates. POPI actually talks about a data breach as where you have reasonable grounds to believe that an unauthorized person has accessed information. So leaving aside people hacking in, you're talking about, as you mentioned, an employee taking their laptop that's not encrypted, flying to Durban and forgetting it on the plane. Someone now has that laptop, and there is reasonable grounds to believe someone else could access that information. That constitutes a data breach under POPI. So yes, I mean, this working from home, whilst this flexibility is great, it really is a lot of benefits from an employment perspective. There are of course a lot of risks from both a data protection and employment perspective. These are in terms of securing your systems. As Zaheer mentioned, someone working with you at home, what are you, how are you taking, what steps are you taking to protect that? And again, you can't isolate as an organization yourself from your employees. When they are conducting work within the course and scope of their duties, they're doing it on your behalf. So, yes, you may get a rogue employee that, steals your data and leaves disgruntled from the company, but you do need to take steps to manage and train employees and put policies in place to govern this. So when they are going to work from Starbucks in this lovely flexible working environment, they cannot join an external network. They should not sit too close to someone else where they have personal information or confidential information. And that really is talking about a team effort. POPI is not a one-man job. Whilst we have an information officer, it really is going to be collectively everyone working as a team. And as Emmanuel mentioned, awareness, training with employees, trying to prevent it, incorporating policies, and just ensuring everyone is aware of what their requirements are under the Act.
Okay, let's go to our polls. I'm going to bring you in now, Zaheer. Let's just go to our quick poll. Our first poll for the morning has been launched on the little chat box on the right. You can just click on polls if you want to partake. The question is, has remote working created new significant compliance challenges for your business? Has remote working created new significant compliance challenges for your business? They've got various answers there. Yes, extremely challenging. Yes, somewhat challenging, but manageable. No, not at all. And unsure. There's 16% that feel that way so far. So here, allow me to let you come in there on what Nadine, the point that Nadine has just made.
So this is just more of a question towards Nadine, and I was very happy to see someone from law included here. And what I'd like to understand, maybe from a law perspective, is we know the fines that are infringed upon GDPR, but with POPI changing every year, the regulation changing. Do we have any visibility in any of the fines or any infringements if someone decides to breach personal information being disclosed?
Over to you, Nadine.
Thanks, Zaheer. Thanks, Marcelle. Yes. So the Act does contemplate a number of consequences for non-compliance with the Act. And firstly, as you mentioned, there can be an imposition of an administrative fine of up to a maximum of 10 million rand. So that is where you've breached the Act, and the Information Regulator says it's sufficient for a fine and can go up to 10 million rand. There are also instances where you can experience imprisonment as a consequence. A lot of people panic around this, but there are only specific acts on which you can result in imprisonment. So, for example, you providing false information to the Information Regulator or obstructing her duties when she comes to your premises to conduct an investigation. But in addition to this, Zaheer, there is now a remedy there's always been a remedy for a data subject to institute civil action against an organization for an infringement of their right to privacy. And in doing so, you would ordinarily look for compensation for any loss caused or damages for any loss suffered as a result of your information being misused. And interestingly, POPI now allows the Information Regulator to institute civil action on behalf of data subjects, which is great for access to courts because it can be a very expensive process. And here the Information Regulator is taking it on behalf of data subjects. And that could be any amount of compensation or damages which someone would have to prove. And there's no limit on that amount. So there are consequences set out in the Act and remedies available. But just interestingly, the 10 million rand fine practically is yes, a lot of money, but the costs of experiencing big data breaches can be significantly higher. Before the Act came into place, with Ebrahim suffering a data breach last year, there was a study conducted on sort of how the costs of a South African entity experiencing a data breach. And on average, a South African entity incurred 40.2 million rand for each data breach. And that's before fines could be imposed by POPI. So that is costs about reputational damage, informing data subjects, operational cost and disruption of business. All those things add up. So as mentioned by my colleagues Zaheer and Emmanuel, it's really important to have this overall, approach where everyone, the three-headed dragon, when you're looking at holistically, you're creating this culture of privacy to try and mitigate not only breaching POPI, but all the other costs that can be associated with not protecting personal information.
Allow me to bring Emmanuel in here. Emmanuel, let's talk a little bit about Trend Micro and the work that you do. Obviously, you work in cybersecurity, but that's not the only thing that is involved in becoming POPI compliant. Why is Trend Micro getting so hands-on involved in this conversation around being compliant around the POPI Act?
Without sounding like a stuck record, many people, when they hear cybersecurity, think technology, and for many companies, technology is expensive. But as we've been hearing and saying, there are other ways and means to begin protecting your data. And companies aren't aware of that. Having a proper framework in place, like, for example, as Zaheer spoke about it earlier, having an identifying and classifying the information in your environment, what's confidential, what is private, what is sensitive, and then creating awareness around that data. Also, understanding your risk, how important, how valuable is the risk, what is acceptable risk and what isn't acceptable risk. If you weigh the costs to the reputational damage, and as Nadine has said, 40.2 million on average per data breach can be quite expensive, but not to mention the reputational damage that accompanies that. Companies and organizations need to start implementing the different cybersecurity practices and frameworks within the organizations. And it, as I said, doesn't have to be expensive when it comes to technology, but if you understand the risk associated with your data and how valuable that risk is you can then start to formulate a plan and a procedure to start implementing security, creating awareness. If I can use the NIST, the National Institutions strategy on technology, is the framework that they use is identify risk, identify your data, and then protect. How you're going to protect your data, creating awareness for your employees is part of protecting that data. Then detecting, having a solution or a 24/7 monitoring service to understand if you've been breached. It's been shown that most companies aren't aware of a breach, and it takes up to 175 days before they are even aware of a breach in their environment. And then it goes on further, it takes another 55 days to respond or recover from that breach. That's almost a whole year that a threat actor has had in the environment to be able to do what they need to do with the data. So detection and having the right skill and people in place to be able to know what's going on, doing pen testing, vulnerability testing, making sure that the technology and the processes that you have in place are constantly tested are important. Also, then responding to that information, as responding to that breach and being able to recover from it is as important. And many organizations, unfortunately, don't have a recovery strategy after they've been breached, how to deal with it and how to recover from it. And so all those things start to play an important role, and understanding those things within your organization is important to starting and becoming POPI compliant.
Well, let's get our hands dirty when it comes to that kind of thing. Zaheer, allow me to bring you in here and also acknowledging our participants. We're going to get to some of your questions in a moment. Zaheer, from a South African perspective, what has been seen as best practice from a data management and storage point of view? We've heard Emmanuel laying the groundwork for why that's important, not just your preparation to keep your information safe, but indeed also what to do when there is a breach of some kind. What's the best practice in South Africa right now, and could POPI change that as well?
Yeah, so I don't think only POPI will change that whole stance. There's actually two things that actually affect it, and I'm actually looking at the poll and I'm seeing that yes, somewhat challenging but manageable is actually sitting at 59%. And if we had to take this back to last year this time and ask that same question, I'm sure that percentages would have been slightly different. And when we're looking at how customers or how companies are actually managing currently their data, it is very different. And the reason being is, when we looked at IT a year before COVID has hit, it was a very decentralized structure. When I say decentralized, they might have 10 branches and everyone is connecting. They don't know where the data is and all of those kind of things. But again, with the pandemic that hit us, this fast-forwarded digitalization. And when we fast-forward the digitalization, that means that we're looking at more of a centralized approach. We're now putting all of our data into one cloud service, and it's very easy to manage. And I'm actually quite proud of it from a South African perspective, where I'm seeing more and more customers actually consolidating their data into a single repository, whether it's a cloud or it's a head office perspective, and then they'll be able to identify the data. I'm actually, even on LinkedIn, when I'm following some of my peers, and more of them are actually going into the data protection officer role. And that is actually quite encouraging to see, where this is now actually being important within organizations. It's too many times when we go to a customer and we start talking about data protection, and the first thing they say is, no, it's too time consuming, it's too expensive, I don't have the right tools, I don't know where to start, I don't know any of this. At least with something like POPI, that actually fast forward that structure from them as well. And they're actually hiring data protection officers, centralizing the data, identifying the data, and now we go into the protection of the data as well. On the flip side of that, we also need to have the recovery portion. Once the data does get leaked, we know there is disgruntled employees. The data is going to leave the organization somehow. Someone's going to forget some laptop somewhere which was unencrypted, and someone stole it and they decided to sell this data. So we need to be able to prepare for that as well. It's all good and well knowing that POPI is there and we want to be compliant to that, but we also need to identify what's going to happen once we break POPI. Because we also need to know everything is not bells and whistles in our environment. Some things are going to happen where it's not going to be in our hands. So we also need to understand that once we do it, how do we handle brand reputation? How do we handle disclosing that breach as well? Because that is very key for our environment as well.
I think that's the perfect time to bring in one of our first questions, Claire Harrison, who's tuned in. She asked, what are the implications of using a cloud-based system such as Google? How do we ensure that we are secure when working on the cloud? Zaheer, do you want to kick us off there in answer to that question?
Yeah, I'll take that one. That's fine. And I think that's also right up my forte, because I'm very pro centralizing the data, because it's easier to manage the data. If you're going to use a cloud-based platform like Google or even like SharePoint Online, because it's a centralized location, it is very easy to be able to have control on the data. We can then implement other security controls like multi-factor authentication, bolster the security on there. Once we understand that this is the data that is quite secure to me, I now need to be able to identify what is important according to the POPI Act. Once I identify the data, I can then control how the data moves in and out of my organization. An easy example could be that the HR department needs access to ID numbers because they need to be able to vet people that's coming into the organization. But the IT team doesn't need access to that. So why should that team have access to the ID numbers, for example? So if I'm keeping everything into a Google or SharePoint Online type of an organization, it's very easy to control the data that's coming in and out of my environment because it's a centralized location.
Okay, Nadine, you want to come in there?
Yes, thanks. Marcelle, the only thing I wanted to add to that point of cloud-based is that generally, it is great. A lot of companies are starting to use clouds a lot more, but the clouds are ordinarily situated in other jurisdictions. And now POPI does seek to regulate the transfer of personal information cross borders. And the Information Regulator has said, the storage or the transfer of personal information to a cloud situated outside of South Africa would constitute a cross-border transfer. So in these circumstances, there is a general prohibition on it, but subject to the fact that the third party receiving that information is subject to a law or binding corporate rules or a binding transfer agreement that provides an adequate level of protection that upholds your principles contained in POPI. So great to use cloud. Probably one of the suggestions I would say is check, where the cloud is situated. If it's in Europe, arguably it would be adequate compliance, although the Information Regulator hasn't yet announced on that. But if you're sitting with a cloud in the US or elsewhere, you may just want to check the terms and conditions with Microsoft, whoever owns the cloud, to make sure that they provide for an adequate level of protection and you have that justification in place.
Emmanuel, did you want to come in there?
Sorry, was that? I didn't hear that question. Sorry. If you asked me if I want to come in.
Yeah, I wanted to find out if you wanted to come in there, just on the question from Claire Harrison about using cloud-based systems.
Yes, I do. So Nadine had a very valid point that organizations do need to be aware of where their information is sitting, and it's part of being POPI compliant. But also, in moving to the cloud, many organizations have to understand what is their responsibility when it comes to security, and what is the cloud provider's responsibility when it comes to security. Many organizations thinking when they're moving to the cloud, and because the infrastructure and everything is controlled by the service provider, whoever they might be, they don't have to they need less security because they're protected by the service provider to a certain extent. But there's a responsibility model that each service provider has, that whose organization, the responsibility for the organization and the responsibility for the cloud provider are separate, and organizations need to understand that. What is their responsibility? And as far as I understand, most cloud providers' data and information is the sole responsibility of the organization that is hosting that data.
Okay, well, we're really getting into the nitty-gritty here because the questions are streaming in. I think I'm going to go immediately to a question from Melissa Dupree, because I think while we still have Zaheer here for the next 25 minutes, we need to pick his brain as much as possible. Melissa's asking a more intricate question. She's asking, what is the process for verification on a historic database on email? Should companies send a bulk communication to urge people to resubscribe? What is the rule in bringing inherited subscribers in line with POPI? Is that for Zaheer? Is it for Nadine? Is it Emmanuel? You guys tell me. Don't all jump at the same time.
I think that falls more in Nadine's space. From a technology
Nadine,
perspective, we can send it.
Okay, Nadine, you kick us off.
Thanks, Marcelle. If I do understand the question correctly, I think it's more geared towards probably direct marketing activities, where you have a database of a lot of clients or customers or individuals where you're actually sending unsolicited electronic communications to them via their email subscriptions, and now you have this lovely database of emails that you want to continue using. And I think where the issue arises is that POPI now seeks to change the approach to direct marketing when you're dealing with unsolicited electronic communication. So SMSs, emails, that sort of stuff, not cold calls or posts, but dealing with emails in terms of the question. The new approach is now an opt-in approach. And POPI says you need someone's prior consent to send it to them. The exception to this is where it is a customer of yours and you obtain these details through the sale of products or services. You provided them with an option to sort of opt in, and the purpose of it is for further sales. So there are a number of organizations that have this huge, valuable database now of emails that they are not sure whether, 9 years ago they collected the information through a provision of a sale. There is no right approach to this. I think, Marcelle, there's various approaches. The most cautious approach, which would not be commercially wise, would be to send an email to, your whole database saying, please consent to us doing this. And people don't like responding to emails when they don't have to. So it's likely you will get a few responses and your database will be completely, sort of just tarnished with no sort of right to email. The other approach that I've seen a lot of entities do, and I've even been on the receiving end as a customer from a lot of entities, of an email sort of the middle ground saying, we've got your details. They were from sort of us providing services to you. And, on this basis, we are going to continue providing marketing materials to you for your benefit. Please let us know if you have an issue. And it is possibly not completely compliant with POPI, but it is the more robust approach to try and let people know, and if there is an issue, they can object to it. So that would be my sort of, answer to how to deal with it historically. But of course, going forward, just make sure that those conditions are complied with.
Emmanuel, let's talk a bit about the industries that probably need to sit up and pay the most attention. When I was doing some research, repeatedly they said industries in the financial services, healthcare, and marketing. But really, I thought surely POPI would have an impact on everybody as an individual. If I think of how many times you go onto a website and they ask you to put in your personal information, and we just do it like we're handing out candy, Are there specific industries that should be paying more attention, or is it everybody, including the individual, that should be paying attention to how we manage our personal information, even if you're just entering a competition on Instagram, as it were?
I think from a POPI perspective, and Nadine can correct me on this if I'm wrong, but I think the POPI Act applies to every organization that is dealing with personal information of their clients and or their employees, and including the organization itself, as Nadine said earlier. So I think every organization has a responsibility to protect the data and know how to protect the data. From a personal individual, obviously there needs to be more awareness of how you are. Don't be frivolous with your data, and understand where you are publishing your data, putting your data on, whether the websites that you are subscribing to, whether they be online stores or whatever, or have good reputations. I mean, that as a private citizen, and for myself, I'm very cautious as to where I put my data. Obviously, I'm in the cybersecurity field, so I know a bit more about it, but I think every citizen needs to be aware of where they're placing their data and how they're sharing that data, and the organizations they're sharing it with is also quite important.
Emmanuel, does this mean that you are one of the only people in the world who's not on Facebook?
I am on Facebook, but I do have colleagues that actually don't have any social footprint, believe it or not.
Really? These people exist? And they're at Trend Micro. Let's stick with our conversation with you, Emmanuel. What is the current state of cybersecurity in terms of South Africa? Where are we positioned in the big picture when it comes to threats and data breaches? I mean, you're just speaking about your colleagues who don't have any social media footprint. Where does South Africa stand right now? I suppose POPI will be a massive improvement from where we are right now.
Absolutely. I think South Africa's come a long way. We're not there yet, and our security has to mature a lot more in the South African space. And just to give you, I read an interesting article where the article stated that many cyber criminals, funny enough, view South Africa as a test bed, because our maturity is not, security maturity is not at that level yet, and it's not robust enough. So there is a lot of work that needs to be done, and I think the POPI Act will definitely help a lot of organizations reach that level and start becoming more aware of their data. Especially, I think the more enterprise level organizations, like the financial institutions, that are already way ahead, but I think the smaller businesses and medium businesses have a way to go before they become more security conscious and more security mature.
Zaheer, did you want to come in there on that?
Yeah, so just to add to what Emmanuel has said, and just to take a step back, also when you ask the question around who POPI actually affects, and normally it's around BFSI, all of those type of industries. And one of the things that we also forget is the public sector industry. And when we're looking at the public sector and merge the two questions together, and we look at the cybersecurity landscape, especially from a public sector perspective, these environments are so large that it's very difficult to manage and very difficult to understand where the data is actually residing. And that's going to go into my next question, or answer the next question, which I'm seeing from a poll perspective, is what is your top security concern? And I can see that data access is 66%, but at 30% we're looking at emails. And we also need to understand that emails is still a very prevalent point, especially when it comes to data security, because it's very easy to opt in and opt out of stuff. And I've been on too many different websites where you're just browsing the website and there's one small disclaimer hiding in the corner where accept cookies, or even if you look at some of the very bad websites, if you go on these websites, there's a small thing in the top corner that says, now that you entered our website, you're giving us consent to mine crypto currencies on your machine. And most people don't even notice that because it's so small. So we also need to understand that from a data access perspective, we need to understand that. From an overall IT infrastructure roadmap for South Africa, I think the BFSI environments are very waxed. The reason being is they got a very robust cybersecurity strategy. They got a financial housing to be able to support those things, because when I'm still talking to customers, they're still seeing cybersecurity as a money maker within the organization. It's a cost center. It's not actually providing any ROI. And what is key now with something like POPI it is actually can be seen as a return on investment. And the reason being, alluding to the fact that Nadine said, brand reputation, the cost of actually paying for this fine at the end of the day, that can all be seen as a return on investment. So I think that's actually going to bolster the cybersecurity industry within South Africa to actually mature their security posture going forward.
Allow me to bring Nadine in here. We have mentioned the EU's GDPR, which has kind of been seen as the global standard, and it's hoped that POPI now brings South Africa into that conversation as well. Quite a few people are saying this shouldn't be seen as a negative thing or something that you need to be scared of, that organizations, like Zaheer has just mentioned, should see it as an opportunity, that more and more, especially if organizations want to play in the global space, if they can show they operate inside a country where there is something like POPI, it actually puts you ahead of the crowd and ahead of your competitors. How does POPI compare globally when it comes to that kind of legislation, Nadine?
Thanks, Marcelle. I mean, POPI was actually interestingly drafted on the basis of the Europeans' last Data Protection Act, right? So in 2013, Europe had a Data Protection Act in place, and we followed that legislation. And in the moment, whilst we were taking, the time to bring POPI into force, Europe sort of went ahead of us and then adopted the General Data Protection Regulation, which is slightly different, but still aligns with their previous Data Protection Act and accordingly aligns with POPI. So we really did follow the golden standard in terms of, data protection legislation globally. There are huge similarities between the GDPR and POPI. There are some differences, of course. We mentioned earlier the fact that POPI applies to juristic persons as well, and not only natural persons. There's some requirements of prior authorization that may be slightly different, but a lot of the provisions accord between the GDPR and POPI, specifically the conditions for lawful processing when you can transfer information across borders. So it is great that South Africa has followed the European legislation, because this is regarded as the gold standard globally. And there's a lot of other legislation that has also taken our legislation into account. Kenya recently had a Data Protection Act come into place about a year or two ago. Mauritius as well, their legislation came to force sooner than ours, but a lot was sort of grabbed from the GDPR and POPI. So I think we are good placed. It really will now just be time to see how it is implemented and enforced, and to see how entities actually use this opportunity, as Zaheer mentioned, to get on board and facilitate the protection of personal information.
Now, Nadine, from what I understand, there will now be a regulator that's put in place to basically keep an eye on compliance for POPI. Can you explain what the role of that regulator will be?
Sure, yes. So there's the regulatory body for compliance is the Information Regulator. And it is a small body that's been established. It only consists of 5 individuals, a chairperson, Advocate Pansy Tlakula, and 2 full-time and 2 part-time members. They have been established to enforce the provisions of POPI. So within their duties, it would include, conducting investigations on companies, considering complaints lodged or objections lodged by data subjects. They've already, before the POPI came enforceable, they were engaging with Experian on the data breach. They were engaging with Facebook. They were recommending steps they can take to mitigate any further damage. And not only will the Information Regulator oversee POPI, they're also going to be overseeing the Promotion of Access to Information Act. And those 2 acts are now going to sort of be twins in a sort of respect and read together, because one is facilitating the access to information and request for access, and the rights can overlap between the 2. So the body will be responsible for both, and they have the powers to, as I said, investigate, ensure compliance, and impose those fines we discussed earlier.
Zaheer, I'm aware of the fact that you will be leaving us soon, so allow me to throw a question in your direction before we say goodbye. Where do you believe, we just heard about the regulator that's going to be put in place, which all looks good on paper, but indeed implementation, we know where these kinds of things is key. Where do you think is the biggest vulnerabilities within the South African context when it comes to the implementation of POPI?
I think this also alludes to the comment I made earlier when we're looking at the process behind data protection. And I think it's very key to be able to understand also the vulnerability when we're looking at it. When we're looking at cybersecurity on a whole, South Africa was not at the forerunner. we're actually now getting up there, we're getting more security controls deployed. And I think that is very key when we're looking at how we're going to be able to deploy POPI. And I think Nadine alluded to this fact quite a bit, that there is a lot of regulatory environments that's going to be applied to this as well. So we're going to have the data protection officers, the rules, the regulations, and especially the fines that are going to be associated with this afterwards. So when we're looking at how we're going to implement POPI in our environments, again, we still need to be able to identify the data and then be able to protect the data at the end of the day. And that is very key, because in our organization, I need to first go and hunt this data and understand it. And I've been perusing the comment section and the questions as well. You can actually see some people are asking that on their website, they got some data, do we have to give consent and all of those kind of things. So those legacy data is quite important. And going forward, we need to be able to understand it from a law perspective. And again, that's why I'm very appreciative that Nadine is on the call, because I'm very technically minded and I can always implement technical controls. But this is not a plain Jane cybersecurity discussion. We also need to understand it from a law perspective, because myself, at the end of the day, I'm going to go there and say, I'm deploying some POPI security controls, and I'm going to assume that I'm giving you the green tick. Then from a legal perspective, we need that green tick to make sure that the data is also secure from a POPI perspective.
Well, let's use this as an example. There's a question from Percival, who has said reasonable technical and organization measures. What security safeguards would be regarded as appropriate? Do we have enough time to answer that question, Zaheer?
Yeah. So I think the first point of contact is don't put your data anywhere. Just go back to writing it on pen and paper, and then maybe we can
it under the mattress.
So our data is always going to be floating around. Whether we're using Facebook, we're using Google, we know the cookies are going to be able to get it. But when we're looking at organizations and how we're going to actually protect the data, I think there is a very minimal baseline of data. And the first component is, if you're going to use cloud services, data sovereignty is very important to understand where the data is living, where it's residing, and what type of protection controls are there in that data center as well. So when we're looking at hosting in a cloud platform, it's not only the big Googles, Microsoft, the Amazons of the world. There is some private data centers that customers are using as well. So we need to ensure that the data that's there is also quite secure. When we're looking at, once we identify the data and we start putting in protection controls for those customers' environments, one of the key things that customers usually forget, and Nadine also alluded to the fact, that is encryption. Encryption is a very important component, because this laptop that I'm working on today can always be stolen. I can forget it somewhere, it can be lost, and we don't know where this data is residing. So even though we can have a centralized security operations platform where we can have all of our data sitting there, we also need to know that this data is going to leave my corporate environment sometime or the other. And the other key component is mobile devices. On my mobile device, I have my email, I got my work environments. We got things like WhatsApp that is going around, where someone will send me data, someone's PDF on WhatsApp. That already breaks all POPI's laws, because there's no data security on that. So we need to ensure that when the data leaves, we need to take the data so that I know where the data is going. And something quite key is, who can I hold accountable at the end of the day? Who will leak this data at the end of the day, so that I can secure this going forward?
Gosh, Percival, if that didn't answer your question, then I don't know what will. But Emmanuel, allow me to, and Zaheer, if you do need to slip out, thank you so much for your contribution today. I'm sure people will be finding you on the World Wide Web if they have any further questions. Emmanuel, we had that question there from Percival. An example like that is like, oh, it's such a vast question that would need a vast answer. From a Trend Micro point of view, somebody comes to you and says, I need your help. I need my business, whether it's a small, medium, or a large enterprise. We need to be more secure. And there's this POPI thing coming. I don't know where to start. Obviously, you don't take a one-size-fits-all approach to that kind of thing. How do you even start that conversation at your organization?
I think the important thing that we're trying to help our clients with is to understand and do an assessment and understand what their current security posture is and where it's at. And so we try and help create a sort of a cybersecurity framework for our customer and try and show them where their weak points and that is. But I also just want to say that I think it has been said that we don't need to be afraid of the POPI Act. I think that the POPI Act is definitely there to help organizations, and the POPI Act has got very clear mandates and regulations and instructions of how data, depending on where it sits, how it's used, needs to be protected. And I think if organizations start there, understanding what data, and Zaheer has alluded to this as well many times, is that if organizations understand what data they have and where it sits, how it is used, how dynamic it is, in the sense that our credit card informations and our identification, and that is it being sent often to our clients, is it moving a lot, or is it at rest? And depending on where the data is and how it's moving, you need to then put the right security in place to protect it in the process. And my advice would be is to start by looking at the POPI Act, understanding how they require you to protect that information, and then starting to put processes, educating and creating awareness, and then obviously having the right technology in place to protect that information.
Okay, Nadine, can I bring you in there for a question from Fatima? She says, which is a nice example. Hi, as an online advertising company, we often host competitions on behalf of our lister, she calls them. We then forward the entrant's contact details to the lister concerned. If we list T's and C's on our website complying with POPI, is that compliant enough?
That is a good question. And I think it takes us to the issue of the C word, consent. And a lot of people, say, oh, we need consent all the time to process personal information. And this is just simply not true. That is a misconception. But there are, of course, instances like the present example where consent would be a good to have. Now, in this case, what you would do, as you said, you have your terms and conditions. You should say consent to not only collecting the information, but sharing it with the lister. The purpose of consent is informed consent. So a lot of people say, well, you consent to us collecting your information. That's not enough. You need to explain to them also, you consent to us collecting it. You consent to us providing it to this third party. This is the uses for it. It goes back to the issue of our privacy notices that we need to inform data subjects what we're doing with their privacy. So consent is always a nice to have. Put it in those terms and conditions, but just a lovely warning that consent can be withdrawn. So the minute at any time by a data subject. So the minute it is withdrawn, you need to stop processing unless you have another justifiable ground on which you're processing it. And those grounds can be for purposes of performance of a contract. So if those terms and conditions are worded in the phrase of a contract that you're entering into with this participant, you would have a process basing without consent. For obligations imposed by law, we've seen with COVID screening, and also just for your legitimate interests as a responsible party. If it's in your legitimate interest or the legitimate interest of the data subject, which arguably, if you're going to allow me to win the competition, I would say it's in my legitimate interest that you process that information. That is also a ground that you don't need consent for. But as I said, consent's always a nice to have, included where you can, but just bear in mind it can be withdrawn.
Emmanuel, do you want to come in there when it comes to that kind of thing? T's and C's? Surely it's not just like Nadine says, you can't just whack it on there and say, you know what, we'll be fine. We'll just say we put the T's and C's there. It's up to you if you didn't read it.
Again, I can't speak to it from a legal perspective, but I think T's and C's are something that nobody likes. And I'll be honest, from my perspective, when a T and C pops up in my face, I just click the next button and I'm done with it without even reading it. And so I think as an organization as organizations look after private citizens' data, I think we're going to have a bigger responsibility to look after that data and make sure that how we use it and how it's and get very clear consent, I think, from private citizens. As a private citizen, I would like to know how my data is being used, and it needs to be communicated to me very clearly, not just through a T&C necessarily, but also, and I think Nadine used an example of how she's been contacted of we've got your data, this is what we're going to do with it. Okay. And I think we need to have more involvement from organizations and their clients.
Well, speaking of consent, there's a question from Ashley, Nadine, and then you can add the comment you wanted to make. Ashley's asking, does one need to get written consent in all written agreements with suppliers and customers. And I mean, when you're running a small organization, that might be easy enough, but if you're running a huge organization, the paperwork will start stacking up, won't it?
Yes, Marcelle, it will. And I mean, just before I get on to that point, Emmanuel mentioned, there is now this need, you need to inform people what you're doing with the information. And that is normally takes the form of a privacy notice, what under POPI may be a processing notification. Now, it's everyone has to come to the party here. A lot of data subjects concerned may complain about the information being used, but they themselves are not reading the information they need to. So a great example is WhatsApp had their privacy policy in place, and they then revised it, and no one had read it before. And now that it was revised and one person sort of read it and said, hang on, this is quite extensive, everyone decided to read it and felt the same. Now, that is, that was in place. That privacy policy has been in place for many years. They just simply updated it slightly. And it just shows the lack of data subjects going to read privacy notice and wanting to understand where their data, where their personal information is being used. So as an organization, obviously have your processing notification, but as a data subject and a citizen in South Africa, take time to go and read it just for your benefit, and to understand how your information is being used and who it's being sent to, for example, Facebook and WhatsApp's instance. And just turning to the question, POPI doesn't require written consent. It requires consent to be informed and expressed version of your will. So you need to have information to provide that consent. This is where the processing, the privacy notice comes in. If someone consents and you have no privacy notice, you haven't informed them of anything, it won't be valid consent under POPI. In terms of all your contracts, you don't necessarily need to have consents in all of your contracts. As I said, one of the grounds for processing of personal information may be the performance of a contract, as it is, without someone saying they agree to it. But just be cautious here when you are dealing with any operators or a third party. You mentioned a service provider in the question that's processing it on your behalf. POPI does require there to be a written agreement in place between a responsible party and an operator that makes the operator put in place security safeguards and undertakes to keep the information confidential. So there are certain circumstances where you are using an operator processing information on your behalf that you need that written agreement in place.
Well, I hope that did answer that question nice and straightforward there. Thank you so much, Nadine. Allow me just to quickly update us on the polls, as it were. The latest poll there, is there an increased pressure for security advice from your business leaders? Yes, high level, 31% are saying that. Yes, moderate level, 50%. No, not at all, 13% say not at all. They haven't been put under any pressure. That maybe that's because they haven't heard of POPI yet. And 4% are saying unsure. The question is there an increased pressure for security advice from your business leaders? Emmanuel, I'm sure this is the kind of conversation you're hearing a lot when people come to you for advice, saying it will be somebody who's been tasked with looking after cyber security in an organization. They've come to you saying, listen, I've been put pressure on because of this POPI thing that's coming. But really, the kinds of things that POPI now puts in very stern black and white is something that really should have been important to an organization right from the beginning, isn't it?
Yeah, absolutely. It's cybersecurity, as I think Zaheer mentioned before, is one of the things that companies don't see as a return on investment, and so don't spend much time looking at it, and they think, we sort of protect it. It's like, you buy insurance, but you're hoping that you never have to use it. It's much effort, and I think with POPI coming into play, I think that's going to create a lot of space and a lot of awareness around how people treat their information. And I think more and more so what was happening is organizations would pass the responsibility of security down to IT, where now we're starting to see more and more as we deal with organizations that it's starting to become, we're starting to get more and more buy-in from the C-level management in organizations. They're starting to appoint CISOs, appoint CTOs who can make sure that their security is in place and is looked after, and more so wanting advice and wanting to understand how they can protect their information and keep them safe from breaches.
Let's talk a little bit about the role of government now. There was an article written just earlier this month. Are we still in May? No, we're not. It's the 1st of June. In the middle of May, there was an article written on IT Web about government's role. And the headline there, I suppose, would have made people a little bit worried, saying, South African government wants to be the co-owner of all data generated locally. And that speaks to the draft policy the department had released, talking about what government is hoping that POPI would do. Nadine, is that something that we should be worried about?
Yes, I mean, it certainly is. There was this draft policy that came in place that has significant implications for data protection. You know, as you mentioned, it sort of contemplates the government having a co-ownership role of any sort of electronic data generated from entities in South Africa, whether it's stored outside of South Africa or inside South Africa. And the main motive for this is national security, you know, the issue of police being able to snuff out organized crimes. But when you read the policy and how basic it is, everyone gets this perception that we're going to have Big Brother sort of looking over us and taking the information from us. Now, you know, my knee-jerk reaction is this doesn't sound right. You know, many of the other jurisdictions have really placed emphasis on individuals' rights to privacy. And here, as South Africa, we are now placing a lot of importance on the state's right, where it's a different approach to what other governments are taking globally. It is still in draft form. There's not a lot of explanation around it. So I would like to, of course, find out more before making certain comments, but it's definitely got implications on the right to privacy, also the issue of intellectual property rights. And the main concern is, you know, is the government going to use this for commercial purposes? You know, if it is the issue of just for national security, there should be some limitations, which it doesn't currently have in place. So the hope is, you know, the Information Regulator is considering this policy. It really is in its first draft form, and a lot of explanation is going to have to come forth from the government as to exactly how it's going to operate.
Emmanuel, your view on this? Just reminding people who tuned in a bit late, Emmanuel started off his working life in the South African Police Service. So where do you stand on government's involvement in playing Big Brother here?
I think I tend to agree with what Nadine just said. And I think, you know, if government is going to be, wants to use personal information, then I think they need to be transparent about what they're doing with the information. Privacy is a concern, and they need to adhere to that privacy. If they're using national security as a reason for it, again, I think there needs to be certain criteria built into that. Again, transparency needs to be very important, and they need to treat data as any organization does, with transparency and informing its citizens what it's planning on doing with the information.
Nadine, did you have an extra point you wanted to make there? Or
yeah, I mean, further, I suppose we talk about this topic for days, and I'm sure a lot of people feel quite strongly and have their views. But transparency, as Emmanuel mentioned, is absolutely key. And also, you know, the issue of the fact of co-ownership is that organizations, and Emmanuel may be able to speak to this with Trend Micro, are using better sort of software and clouds overseas in order to centralize their document data and better protect it. Now you have this issue of government saying, okay, we'll co-own it, and please make a copy of all your data that's now going to be stored by government. Now, you as a private entity has spent all this money on putting in, you know, the correct cybersecurity tools and clouds, and now you have to sort of use your own resources to make this copy to be put on a government system. So from that way as well, there are concerns about costs and spending that an entity is doing to protect their information, and now simply replicating a copy and handing it over. This may impact on investments, of course, on trade, on people coming in the country. So a lot to think about. I suppose I'm just getting the ball rolling on these topics and these issues for when hopefully a revised draft comes out, but it's certainly going to have a closer look at. Yeah.
Emmanuel, let me bring you in there. Nadine did open the door there for you. Let's talk a little bit about innovation in the space that you guys operate in. Obviously, this is really going to open up the floodgates when it comes to the different ways that organizations can secure their data and their information. Well, what's the latest thing out there from an innovation point of view in cybersecurity?
Well, we've seen a lot of innovation and a lot of change within the COVID-19 pandemic. People have had to adapt, obviously working from home and that, and we've seen a lot of innovation around. And what's become very important is, in the past, people were using anti-malware to protect their desktops and their servers, but we're also starting to see a big need, as I mentioned before, for threat detection and response. People aren't aware that threat actors are in the environment, and as I said, it takes up to 175 days to identify that there's a threat actor in your environment, and then another 56 days to get them out of the environment. So having the right tools to be able to detect and respond to breaches is very important, and we're seeing XDR, cross-tech detection and response technology playing a very important role within many organizations. As well as we're starting to see where people are now working from home and having to connect. There was an explicit trust sort of model, assuming that if you are an employee of the organization or you're a partner and you've got an account within the organization and a laptop issued by the organization, we trust you to come into our organization, assuming you're using VPN. But what is happening now, many, and especially enterprise organizations, are starting to move the entry point closer to the resource that is trying to be accessed. So we call it zero trust, or reevaluating the trust of the employee, checking as to whether the employee has had any suspicious activity on their account in the last few days, reevaluating their laptop to see if it's had any malware in the last few days, where are they coming in from, and that's the sort of technology that clients are starting to, organizations are starting to move towards, as well as the cloud. There's been a huge cloud adoption, fast and more agile with their applications to get it out to market as quickly as possible. And we've heard to use the word DevOps. It's happening quick and agile, and many take security into consideration when they've got a DevOps environment. So we're starting to see DevOps type protection and security, where you're protecting your environment from the word go, when you're busy building your code, all the way to when it's deployed in the cloud environment. And that's the sort of trend we're starting to see growing, and tools and innovation that organizations need to protect their data.
Just a reminder to those watching us, you can still throw a question or two into our chat room. Let's take one now from Dylan Cutter, and I think Nadine, perhaps you can take this one, or Emmanuel, put up your hand if you want to contribute. How will companies that sell leads to other businesses operate? How do they ensure that those leads are compliant? Also, how do companies use leads that were bought prior to June 30th, 2021? Of course, one forgets that there's this entire market of information that's not just exchanging hands, it's being bought and sold as well. Where does POPI sit in that regard, Nadine?
I'm going to hand over to Emmanuel. On this one first. I definitely think it's more of his issue, and I'll jump in with any legal considerations thereafter. But really, I think this topic falls directly into your cyber security.
You've got the hot potato there.
I do, and I'm actually trying to understand the question. So, Marcelle, would you mind just reading the question again?
Yes, sure. So Dylan, and if Dylan is watching and waiting for an answer, if you want to be a bit more clear, just type away, and I'll check if you put it there a little bit clearer. But he said, how will companies that sell leads to other businesses operate? How do they ensure that those leads are compliant? And how do companies who use leads that were bought before June 30th, 2021, how do they ensure that they are compliant?
Sure, it's a big question, and a good question at that as well. But I think again it comes down to understanding what POPI is and how you need to comply with the different information, whether you're selling leads or whether you have leads that you have taken over from another company, whether they be employee information, client information, whatever it might be. There's also a requirement in the POPI Act to understand information that is no longer needed and how you deal with that information. For example, whether it be, for example, you have an employee that's left the company, you might have a compliance regulation that you need to archive your data and keep it for 7 years for compliance reasons and auditing reasons. But then after that, what happens to that data? Are you going to keep it? How are you going to destroy it? How are you going to get rid of it? How is it going to continue sitting in your archived environment? And how are you protecting that archived environment? And so all these things need to be considered. Many people don't consider stagnant information that's been that is no longer in use. They just leave it there, and again, that information can be breached, can be compromised, and information can be leaked out into the into public space. So things like that have to be considered. How you deal with that information, whether it's moving, and how you're selling it, and how you're trading with it.
Nadine, do you have any contribution there, or do you think Manuel's covered your back?
I think he's covered. I think he has covered it. It is a complex question, but as Emmanuel mentioned, I mean, you know, one of the starting points in your whole organization is to develop a compliance framework to ensure compliance with POPI. And in order to do that, you do need to conduct an internal audit on leads you've received, on leads you sort of have to understand what personal information you collect. Is it ordinary personal information? Is it special? Where is it held? By whom? What purpose is it? And only once you have all that information can you start ensuring compliance with the 8 conditions for lawful processing under POPI. That includes, as Emmanuel mentioned, your retention requirements, but your security safeguards, the justifiable basis on which you're processing. So the process really starts off internally in an organization, assessing what you have, where it is, and then taking steps to find out what you need. And if you don't need to reinvent the wheel and have a lot of processes already in place, you just then need to work on those to ensure compliance with POPI.
We're going to start winding down our conversation now. You are watching Scenario Planning in a POPI World, Unpacking and Preparing for the What Ifs, a webinar hosted by the Mail and Guardian in association with our sponsors, Trend Micro. And perhaps a question to both of you. Is South Africa ready for the Protection of Personal Information Act and its implementation? Emmanuel, let's start with you.
Yeah, Marcelle, I think we are ready. I think we've been ready for a long time, as it's been in the pipeline for 5 years. I think where people might fall short on is, again, assuming that the POPI doesn't apply to the organization because they're a small business or a medium business, and they might not have started putting the right procedures and frameworks in place to protect their data. But I think in large, most of our enterprise, and we're talking financial institutions and industry, retail, and that have already started working on becoming compliant toward POPI. So I think we are ready for it, and we're getting there. And again, I want to encourage people listening is it's not a scary thing. It's just finding starting somewhere with POPI, understanding what as Nadine said, and as we've all said, is what data you have, and then just get a process of educating your users, understanding what data you have, understanding the processes behind the data, how it moves, and then getting the right technology in place to help you protect that data.
Nadine, do you think we're ready?
We are ready. We have been ready. I think this is now the time. You know, we do need this legislation. It's great for us as citizens of South Africa, but also as entities really to bring in business, to work with businesses overseas, and to align South Africa with international standards. So now is the time. And I think my one message, similar to Emmanuel, is don't panic. There is a lot of panic. We're down to the 30-day mark. And the question I've seen, I think one of the questions was, well, what do we do? What does that mean? What steps can we take? And I think if I can just take a bit of time now, just for some of the steps, there's a lot of nice to haves, and, maybe even best practices that may result or come about after we've seen how the Information Regulator is going to enforce the Act. But for now, specifically for organizations who possibly haven't even started their compliance journey, I really would just, as I said, don't panic. There is a few obligations imposed by POPI that I suggest you maybe just note down and take forward to start your compliance journey. And as alluded, the first one would be, as alluded to, Zaheer earlier, was you need to appoint and register an information officer. Obligations on information officers by the 1st of July include, as Emmanuel mentioned, establishing a compliance framework. You need to have a compliance framework in place. It's updating your PIA manual and conducting awareness sessions with your employees. Those privacy notices are crucial to comply with the conditions for lawful processing, and then just finding out whether you are using clouds or transferring information across borders. Those are just some of the steps where I'm trying to give action points where you can start and look at, and obligations placed on organizations. But start somewhere, take one step at a time. As I said, get buy-in from key stakeholders, from your employees, make it a group effort, because it really is going to be something that should be viewed as quite an exciting opportunity for a business, as opposed to just further legislation obligations.
While we've got you front and center, Nadine, can we talk a little bit just about the penalties and the consequences? I suppose the question is, can I go to jail if I'm not POPI compliant? What are the most important factors people need to keep in mind when it comes to compliance versus non-compliance? How much hot water can they get into?
So great, Marcelle. I mean, I think obviously financially we have that administrative fine of up to 10 million rand. And yes, there is imprisonment, which is quite unique in terms of POPI, but it really is if you are misbehaving. So it is where, you are giving false evidence by way of affidavit, you're obstructing the regulator, you get issued with an enforcement notice, and you fail to comply with it. So generally how, everyone's new to it. It's going to be new legislation. We don't know how the information regulator is going to implement it. But what I do understand is that, if you're not in compliance, you will, an investigation may happen and there may be an enforcement notice, which will give you an opportunity to then remedy or try and comply from them. It is in the event that you're not then complying with the enforcement notice that you could, get imprisonment or a fine. But just again, bearing in mind, if there is a breach and something does happen, even if you are in fully compliance with the provisions of POPI, and you unfortunately have a fraudster phoning in and getting information from you, there are those damages that could result in civil action being imposed on you. So one of the things that are maybe nice to have, as I said, I wouldn't mention nice to have, but one of the things to maybe revisit is your insurance policies. A lot of your business insurance doesn't cover data breaches or losses from data, and that's something you may want to just look into, just considering the cost.
It was bound to happen, and it's me, of course. Emmanuel, we've heard there about the consequences and the penalties for non-compliance when it comes to POPI, but like we've said before, it should be seen as a positive, because I do think that if organizations pay attention to what they do to be compliant, it just gives them massive peace of mind from a business point of view, won't it?
Yeah, absolutely. And I think if organizations, we tend to think of ourselves, when we're in our organization, we've got a certain hat on. And when we're outside that organization, we put on a different hat. But I think if we all consider ourselves as private citizens of South Africa, and we want to ensure that we are not conned, or our information is not leaked, and we all want our information to be private and protected. So I think it's a positive thing for all South Africans to know that we live in a country and are dealing with organizations and businesses that are looking after our data, are protecting our data and protecting our interests when it comes to that data. And I think that's why I think POPI is a good thing. And again, as we've said before, it's not a thing that needs to scare people. We've talked about those fines and that, but I think when you understand POPI and what it's there for, I think it's a good start to getting your organization compliant and going.
It seems a few of our viewers are very much looking for practical advice. Dennis has written there. So in terms of the compliance framework, we need to update our manuals. What else? I think Nadine's mentioned quite a few. Nadine, is there anything else you want to mention to Dennis there?
No, I suppose to Dennis, just to say that please register your information officer first. That is a must do. The online portal's been made available by the Information Regulator to register your information officer. That is by default in terms of legislation, your head of your body, but you can appoint someone else to do it. That is a must step. The compliance framework is an obligation by itself. It is, as Emmanuel mentioned earlier, it's there to demonstrate how you intend to comply with each of the provisions. The manual then is actually not part of the compliance framework. It is your manual in terms of the Promotion of Access to Information Act. It was there, I think, as far back as 2000, which was facilitating requests for information. That manual will need to be updated to facilitate requests for personal information. conduct awareness sessions for your employees. That is one of the legal obligations on your information officer. Again, as Marcelle mentioned, we've discussed the privacy notices. Consider your operator agreements. Do you have written agreements in place in compliance with POPI? I think those are the go-to steps at this current point in time.
Interesting question here from Karina. I don't know if it's interesting from a news person point of view. I'd find a story like this interesting. If a fraudster phones in and data is released, who will be liable for the fine? The company or the employee who gave away the information? Nadine, do you want to take it, or Emmanuel?
Sure, the company. The company would be liable. This is general, even in terms of common law. If an employee is acting within their course and scope of duties, your employer is by default liable for any harm that is caused. So it's not to say you can't discipline the employee if they didn't follow proper protocol or your processes in place, but ultimately it won't be the employee, it will be the company that will be held liable. So try and get some training in, make them aware of what they need to do, protocols in place. And if it does happen, which it will, it's likely to happen in this day and age of cybercrime, just ensure that you've done everything you can to comply with POPI. Because, as Emmanuel mentioned, breaches are probably going to become, just a common thing. They're going to be a reality like death and taxes. We're going to get data breaches. You can only do so much to prevent them, and the Information Regulator will take this into account.
Just one last look at our poll. Is there an increased pressure for security advice from your business leaders? 44% says yes, moderate level, and 40% says yes, high level. So I think it's safe to say that yes, there is increased pressure for security advice from our business leaders, because people realize, oh, the clock is indeed ticking. There was a question from Alfred who was asking whether the recording of this webinar will be available. It will be, as far as I understand. It's normally emailed to the attendees who signed up for this webinar, and you're asked to distribute it amongst your colleagues, amongst your friends and loved ones who you feel needs this information. One final question I think we have time for. Emmanuel, what is the one thing South African businesses need to ensure is in place from a security standpoint with POPI looming?
The one thing I can say and give advice on is to, again, it comes down to identifying what data you have in your environment. If you don't understand what data you have in your environment, what's private, what's confidential, what's sensitive, and then create awareness around that data for your employees and how they should treat it, you're gonna struggle with becoming compliant. And I think that for me would be the one place for organizations to start to really understand what information they're dealing with, how it's moving, and where it's sitting.
And Nadine, your one thing?
For security, I suppose exactly the same.
And also from a legal point of view.
Yeah, legal point of view, the same steps. Emmanuel, one of the things is to revisit your security. The question was given earlier about what is reasonable, appropriate, security measures. And the only way you can tell whether it's reasonable is to assess the information you have, where it is stored, who is it held. Again, it's not only electronic information. Make sure if you have your hard copy, not stored under your mattress, but in your office, it must be under lock and key or in a fireproof safe. Revisit these, assess the risk to the information, and then you can implement good security safeguards that you can get guidance from international security standards. We spoke about encryption, antiviral software, anything that is good international standard practice, you should be putting in place.
And then just finally, obviously we gave, our panelists gave so much information for people to take in. If they are looking for a resource as to where to find the right information around compliance, Nadine, where would be the best place for people to go?
I would like to say Bowmans, but I'll leave it at that. But I must say the Information Regulator's website, the official website, has great information on it, has all your documents there. She's published all your guidance note about registration of the information officer that we spoke about, prior authorization. I saw there was a question, we didn't quite get to it, but there's a full guidance note there on it. It is a very valuable website. So any sort of, if you're looking for what, the legislation says, what guidance the Information Regulator has given you on how to comply, that is a great first place to look.
Last note from you, Emmanuel, where's the best information people need to get? A Trend Micro being one of them, I'm sure.
Yeah, Trend Micro definitely is one of them. And people, without being facetious about it, is that people are welcome to contact Trend Micro and try on the system and give them advice as best we can. But also, there's many forms of information. For example, our website, the Trend Micro website, we're constantly releasing articles there on the different security trends, how to protect your data, what to look out for, how to create awareness. Trend Micro, for example, has got a Fish Insights awareness campaign where organizations can create awareness for their employees. So yeah, definitely we are there and willing and can help.
Well, information, and we've given people a lot of that today. I think that's the perfect place to leave it. We've already got people in the chat room. Janine saying thank you for this info session. Tumelo says thanks for the valuable information. Quite a few comments of people thanking you guys for lending your expertise today. So do I. I feel far more educated. Scenario planning in a POPI world, unpacking and preparing for the what ifs. I don't feel like a POPI about this anymore. I feel a little bit more informed. This conversation, this webinar has been brought to you by the Mail and Guardian, along with our kind sponsors, Trend Micro, who are leaders in cyber security, hoping to help make the world safe and for exchanging digital information. And that's really been our major point of conversation here. Thank you so much for joining us. Thank you to our panelists. Zaheer Ebrahim was with us earlier, the sales engineer at Trend Micro South Africa. Emmanuel Tzingakis is the technical lead for Trend Micro Sub-Saharan Africa. And indeed, Nadine is a senior associate at Bowmans, specialising in employment law and data protection. Thank you so much for your expertise. And thank you to everybody for joining us. And they're all giving their thanks on the chat room. That's always good to see. Be sure to go on to the Mail and Guardian's webinar website to see what next for what they've got planned in terms of informational and educational and interesting webinars that they have planned almost on a weekly basis. So be sure you stay tuned. Thanks for joining us. Stay safe out there, South Africa. Until next time, goodbye.
Bye-bye.